Hi, my name is Ryan Young. I'm an attorney in Fairfax, Virginia, and I serve clients throughout Northern Virginia. I'm here today to talk to you about guardianship and conservatorship within the Commonwealth of Virginia. Now, although I am a Northern Virginia attorney, I want to let you know that these rules apply throughout the Commonwealth of Virginia because guardianship and conservatorship are both clearly defined by the Virginia Code. So if you have any questions, you can either contact an attorney such as myself, or you can look to the code for answers at your nearest law library. Guardianship is not just for the elderly. One of the saddest cases that I worked on was where a young person was severely brain damaged due to drug abuse, and they needed a guardian and a conservator for the rest of their life because they were mentally incapacitated. So you may know of someone who is younger that possibly needs a guardian or a conservator. I want to talk to you about terminology for a minute. Prior to being declared incapacitated, we call the person who may or may not need a guardian, we call them the alleged incapacitated person. After the court declares them incapacitated and appoints a guardian or a conservator, we refer to them as the ward of the guardian. The court must declare the person incapacitated first, and they need detailed evidence from family members, treating physicians. They need detailed evidence and possibly a diagnosis and prognosis for the individual. The court does not take this decision lightly, nor should they. A guardian and conservator may be appointed in the same proceeding. It does not have to be a family member. Anyone under the Virginia Code, anyone can apply to be guardian and conservator of a person. But, however, sometimes it does get ugly when family members fight and these matters become contested. A guardian is in charge of the medical and personal care of the ward. That means they make medical decisions, treatment decisions. They have either broad or very limited powers depending on the order of the court. Same thing with the conservator, except the conservator is in charge of finances and property of the ward. Now those powers can be limited or very broad depending on the order of the court. There are some ways that guardianship and conservatorship may be avoided, and you should avoid them if necessary, if possible. Unfortunately, many family members wait until it is simply too late. But a person can avoid a guardianship or conservatorship by drafting a power of attorney, a general durable power of attorney, or an advanced medical directive where they appoint an agent for themselves, a medical agent for themselves. Now, I have provided legal counsel to people in some situations where a family member or an outside person came to the elderly or incapacitated person, stuck a power of attorney under their face and said, "Sign this." Unfortunately, they don't have the best intentions in mind sometimes, and it does lead to litigation, and a family member may have to step up and challenge that and apply for either guardianship or conservatorship of the person. If you have any questions, give me a call. I'd love to send you a brief free brochure that details what I spoke of today, and I would love to hear from you. Any questions that you have, you may find my email, my web address, and my phone number at the bottom of this page. My own family has struggled with having to declare someone incapacitated. I know it's not a simple decision that families come to, and it's not one that I take lightly either. I want you to know that I will treat you with the utmost respect, and the ward, the alleged incapacitated person, with the utmost respect. I look forward to hearing from you and learning how I may be of assistance.